And that's the local district taxation. That is the only way that the problem will be solved, because that is the statewide taxation is the only way to assure uniformity. Once you start dividing up into local political subdivisions, and giving them their own independent power to tax, you have created the circumstances, you have sown the seeds that will lead to this situation again.
Well, let me inquire specifically about that, because you suggested several things that I think some of them, of course, quite appropriately not dealt with at the trial court level. If we want to prevent repeated intrusion over a long period of time before the problem gets resolved, I hear you saying what we need to do is be very clear and explicit in our direction to the legislature. Is that right?
Absolutely.
And the specific things that I noted that I don't find in the trial court findings is first, of course, the trial court wouldn't have reversed Love versus the City of Dallas, and you think that would need to be done.
Absolutely.
Is that right? And then second, you think we have to reconcile whatever we do with Love versus the City of Dallas with the more recently adopted Article 8, Section 1E, concerning the prohibition on state ad valorem tax. Is that correct?
Yes, sir.
And then you think that we need to take a look at the meaning of Article 3, Section 56, the 1927 amendment concerning special laws on districts.
Article 3, Section 56 was in the Constitution since 1876. It was abrogated by the
27 amendment.
More specific. Well, the legislature was originally prohibited in 1876, given specific Article 7, Section 3 permission, more specific controls over the more general, from the period of 1883 till 1927.
And you've indicated there is a way to reconcile that concerning statewide purpose of what
it is conceivable that a way could be to reconcile.
Other than those three things, is there anything else not found in the order of Judge Clark that would need to be done so that it can be crystal clear how to remedy this situation?
No, Your Honor, I think if you can find a way to eliminate to give the state access to the local tax base, which, by the way, was the basis of the Kentucky decision, because they ruled in 1965 that that was a state tax. Of course, we have the additional problem of 8 Section 1E in this state that is a difficult problem, to be sure. But if you do that and give the state access, there are mechanisms. The state can set the maximum tax. The state can also theoretically set the minimum tax under its authority under Article 7, Section 3. So the problem is access to that locally raised money. That's what creates the problem.
Everything that you mentioned in response to the questions here would essentially be dicta, would it not? Because all this court can do is order certain state officials not to spend certain state monies.
No, Your Honor. Consonant with I think that consonant with your, I don't think you need to order a state official not to spend state money. Once you have held the distribution statute unconstitutional, there is no authorization for the expenditure of state funds. What the court can do is enter a declaratory judgment declaring, I think, and it is perfectly appropriate with this court's role, what the Constitution requires. And having done so, then the legislature would have clear guidance with respect to the nature of the constitutional mandate, which has not existed heretofore.
Could the legislature solve some of this problem with an additional sales tax?
The legislature obviously could ameliorate. The problem that we have is the problem that we had in this case. As illustrated by the information that we sent you with respect to the new statute. As long as the local independent school districts remain free to raise their money, the state has put in a substantial amount of money, $450 million. 2/3 of it went to the 1/3 poorest school districts. A substantial amount of money on a per capita basis, about $250 per capita for those kids. Using Mr. Kaufman's analysis, that's a lot of money per classroom. All right. What has happened is, though, is that relatively we have stayed the same. I disagree with Mr. Kaufman and Mr. Gray's analysis that things have gotten worse, because in addition to putting in the new money, we have shifted funds from the richer districts down to the relatively poorer districts. So that the money that's gone down to the poorer districts has increased more than the amount of the appropriation. But during that same period of time, free as they are under the current constitutional interpretation to raise taxes, over time, these districts have, the richer districts have raised their taxes. And so what you see is the expenditure level's about the same relative from one end of the spectrum to the other. The level continues to rise because the legislature has consistently appropriated more money, but they're chasing the higher property wealth districts. So you never, what is the constitutional standard? An absolute amount of money? A relative standard of equity? Is it, how do we judge that? We don't have any guidance with respect to the Constitution other than the historical context in which it was created.
Mr. O'Hanlon, in response to Judge Doggett, you listed Article 7, Section 3, Article 3, Section 56, Article 8, Section 1E. Are there any other constitutional roadblocks that you might see toward any legislative solution?
Well, with respect to the appropriations problem, we have the Article 8, Section 22 problem, which is the restriction on the amount of increases in general revenue expenditures on the state. Those are it, of which I'm aware.
Were those limitations brought to the attention of the trial court?
Yes, sir.
Were they ruled upon or acknowledged in the findings of fact or conclusions of law?
No, sir. They were not.
Any other questions? Thank you, counsel.
Thank you.
The court will now take a last brief recess.
The audience will please rise.
Thank you. Be seated. The court is ready to hear a rebuttal argument from petitioners.
And please, the court, Mr. David Richards, will present all the petitioners' rebuttal.
Thank you, Your Honors. In opening rebuttal, I think it would be useful to try to reestablish what we believe to be several sort of anchors that might undergird the analysis here. First and foremost, of course, Article 7, Section 1 does provide, as we all recognize, a duty upon the legislature to make suitable provisions for an efficient system of public education. And that notion has been with us since the Constitution, at least it seems to me, of 1845. It is a notion that's nothing, it's new, and it is part, there's nothing new about it, and it's part of the foundation of our state. Three ideas have emerged, it seems to me, through court decisions under that provision. Education is purely a state function in Texas. This court in Webb in 1901 said that the function of education is a state function, though local school districts are nothing more than state agencies and local school officials are nothing more than state officers. The same was said by this court in Mumm versus Mars, where this court said our public schools are essentially state schools. And Mumm did say precisely that, as suggested by Mr. Justice Doggett, that it was a mandatory duty on the legislature, nothing hortatory about it, a mandatory duty on the legislature to make suitable provisions for the support and maintenance of an efficient system of public free schools. Second, school districts are mere creatures of the Texas legislature. Lee versus Leonard. Creatures of the Texas legislature. That's all they are. They have no standing separate apart from what the legislature gave them. Finally, school districts may be changed at will by the Texas legislature. That's the Texas Supreme Court in Prosper, 1933. The Texas legislature has authority to change at will the territorial boundaries of any school district and to provide the mode and agencies by which such change shall be effective. Prosper Independent School District, Texas, 1933. It is a state function. It is totally state-funded. Indeed, Mr. Kirby, who is the defendant here, Dr. Kirby, has authored a book along with our other expert witness, Dr. Walker. It's Plaintiff's Exhibit 235, called The Basics of Texas Public School Finance. I quote from that book: "Education is a fundamental interest of the state, and the state has both the authority and the responsibility for education, including the methods of raising revenues and allocating funds for schools. Moreover, all school property is state property, all school funds are state funds, and all school taxes are state taxes." Now, mind you, I recognize this person is not this court speaking, but at least that is the perception of the defendant, head of the State Board of Education, and is totally consistent, we think, with the historical view that this is a state function. And we've listened to the state throughout the months of trial and now and again attempt to divorce itself somehow from the results. And it reminds me, I use occasionally Tom Lehrer wrote a song once back some years ago about Werner von Braun, the German rocket scientist, who would say, look, we just sent the rockets up. Where they come down, that's somebody else's business. Well, I sort of sense that about the state when they say about this school finance system. We just sent it up, and if it comes down in this kind of chaotic fashion that it comes down in Clayburgh County, we have no responsibility. Now,
But if it's a state system and state funding, doesn't that mean again that all we're really talking about here is either spending more money on education or spreading the money that we're spending around in a different way? Does it come down to that?
I thought you were pretty close on it all along, and I'm not really going to argue with you. It is a matter of how we're going to raise our money and where we're going to spend it. And do we spend it equally, or do we leave it in this chaotic, inefficient fashion?
But we've either got to make everybody mediocre, or we got to spend more money on the system.
Now, you've got one yes from me. I don't think you're going to get that yes from me. I mean, there is
I'm
obviously...
afraid I might push it.
Mr. Richards,
But that isn't...
what you're saying is that we're not spending it efficiently.
We're doing nothing efficiently. We are not allocating our resources efficiently. We haven't created districts that make any sense, and we are using funds unwisely. That's one part of it. We probably are not adequately funding it either, which is another piece of it. And the State Board of Education said it. I don't have to say it. They said we're not funding it adequately. Everyone who looks at it says that, but it is a constitutional obligation at least to do what efficiently with what you have. Create units that are efficient and take the resources and spend it efficiently. It is not efficient for the Santa Gertrudis district that has 78 students, does not maintain a 12-year system, 6 grades, sends their kids to Kingsville, I think, after the 6th grade, right? Sits right next to Kingsville School District, which has 5,000 students at an 80-cent tax rate. Santa Gertrudis had an 8-cent tax rate. Sits next to Ricardo with a $1.32 tax rate. Santa Gertrudis spending $13,000 per student, and Kingsville spending $3,000 per student. Now that runs throughout the system. I mean, this is not a sport, incident. It runs throughout the system. The top 200 districts, the poorest 200 districts in Texas, tax at 74 cents per hundred, which is above state average. It was about state average. We're spending $3,000 per student. The 200 wealthiest districts were taxing 58 cents per hundred. That's 16 cents less, and spending twice as much per student, $6,000 per student. Now that's the reality of the Texas school finance system. And this chart sort of shows you what happens. The poorest districts have to tax at 37 cents almost, a $100 valuation, to raise $100 per student. The wealthiest districts at a cent raise $100 per student. And the chart graphically, I think, shows that. And as we have said, as has been said, $100 per student or $200 per student this is significant money. If you assume that that the Texas now mandates that the student districts can afford it, 22-to-1 class ratio, 22 students to each class. That's $100 at $22,000 per class. That can easily be part counselor, it can be instructional aides, it can be aides to the student, a teacher. This is real money to an educator. And so when we talk about differences of $500 expenditures per student, we are talking in an educator's sense to real dollars that translate, we would hope, into real achievements that might combat a 45% dropout rate in the Texas public school system.
When you said $100 per student with 22 students per classroom, that's $2,200, not $22,000.
Excuse me, $2,200. My math guy said, thank you, Judge Cook. I thought, quite right, excuse me. Which in and of itself is money, I should say.
Is your figure 45% dropout?
I'm sorry, the testimony record is 45% Hispanic dropout rate. That's the record in this case. In Texas, the total dropout rate is right at 35%. I believe the record evidence in this case.
That's an average, there's higher in some districts.
Higher in some districts. That's correct.
Higher in the poor district.
Well, it is higher. That is a harder argument to make. I do not want to assert that. It is high in urban districts, some of which are wealthy districts. That's a reality too. But it's certainly high in poor districts. And it is also clear that the existence of wealth does enable dropout combat programs, and there is evidence in this record.
What comment do you have to the state's chart, if you saw it up here earlier, showing general revenue funding levels?
I have 2 or 3 comments. One, that was not in evidence in the trial court, which seems to me it's a little late in the day to produce an exhibit that has not been previously tried, at least someone cross-examined about it. It includes revenue, for example, it includes textbooks, it includes federal revenues, it includes co-curricular activity. It does not include expenditures for facilities. If the court wishes, we could look at the state's own exhibit in the trial court, which was testified to by its expert witness Moak, is State's Exhibit 47. And without going into it, that does show both expenditures and revenues. And it would show you, I think, if you stripped out federal funds, which the testimony is in this case, basically federal funds are for school lunch programs. They are not directly related to the educational content. You will find the same sorts of disparities that we talk about. That is, you will find disparities in the level of $1,500 per student of ADA differences between the wealthy and impoverished districts. So I would think if the court wants to look, it would be better to look at the matter that we're putting evidence in trial court, we're tested by cross-examination and credited at the trial court. In connection with a colloquy in that regard earlier about the state's witness Moak testified, as did Walker, but state's witness Moak testified that in terms of efficiency, if you took into account, that is, if the legislature or this court took into account the configuration of the districts in Texas, that is, the fact that they harbor vast differences in wealth, high levels of students, few students, it was beyond question that the system's efficiency could be significantly improved if one took into account the fact that districts were heart and soul of the scheme, the funding scheme. And as to the new legislation, I will make a comment too. The study shows that there are 103 poor school districts in Texas which cannot, within the state funds sent them in this new legislation, fund the mandatory teacher salary increases. I hope I'm making that clear. This new legislation mandates teacher salary increases beyond that which was provided by the career ladder that was adopted in House Bill 72. It's an additional, I think, $1,400 per teacher increase. Now, the money that is being sent by the state, that is additional money, is not adequate to even fund that increase for 103 school districts in Texas. Now, That seems to us has always argued several things that are problematical in terms of constitutional sense. It has always offended my notions of due process. Do you say to a taxpayer, you say to taxpayers in these districts here, for example, you have to fund out of your tax base, that is your tax dollar, you have to fund a new teacher salary increase. Now, for you in Senator Cruz, that probably not going to cost you anything. It may cost you a penny.